Section 24 of the Watergate Report, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 3. Chapter 8, The Hughes-Rebozo Investigation and Related Matters, Part 17. H. Return of the Money. Mr. Rebozo testified on March 20, 1974, that he first decided to return the Hughes contribution in March of 1973. Rebozo also testified that he began trying to contact Danner in order to convince Danner to take the money back around March or April 1973. However, later on at the same executive session, Rebozo testified that he in fact made no efforts to contact Danner to have him take the money back until after he met with the Internal Revenue Service. Mr. Rebozo's first interview with the Internal Revenue Service was not until May 10, 1973, thereby placing his efforts to have Danner take the money back after that date. Rebozo also testified that after he talked to the IRS, William Griffin was the first lawyer to whom he spoke about the money. Rebozo also said that the time at which he first spoke to the lawyers that he mentioned in his testimony was after he met with the Internal Revenue Service. In his first interview with the Internal Revenue Service on May 10, 1973, Rebozo asked the agents interviewing him what he should do with the money, whether he should give it to us, the agents. In that same interview, Rebozo also told the agents that he had considered calling Danner several times and offering to return the money, but that he had never done so because he was afraid that he would create some additional publicity. On October 17, 1973, Rebozo told the Select Committee staff that he had decided to return the Hughes contribution prior to his discussion on April 30, 1973, with Herbert Kalmbach. In addition, on October 17, 1973, Rebozo stated, "I know I had a little trouble trying to get it back, and exactly when that was I don't know, but it probably was in 1973. It's very likely that it was. And once that decision was made, I'm sure I mentioned it to a number of people, but up until then, even Wakefield himself, who was on the box, didn't know. Well, not up until the time we took the money out. He didn't know what he was on the box for." Rebozo also testified on that occasion that it was March or April 1973 when he first told Danner that he wanted to return the money. In addition, Rebozo testified about his meeting with Herbert Kalmbach as follows. Lenzner: Yes, how about Mr. Kalmbach? Did you ever discuss this with him? Rebozo: I probably told him about it. He was involved saw him several times at the White House and in California. Lenzner: And do you remember how it was? Were you seeking his advice or counsel? Rebozo: I don't think so. I think it was just a general discussion. You see, Kalmbach and I have business discussions, naturally on the San Clemente interest. He and I worked on the Yorba Linda house. Rebozo later on testified further about his meeting with Kalmbach. Lenzner: Do you recall if the two $50,000 contributions came up? Rebozo: Yeah, I believe I told him about it. That may be. Lenzner: Do you recall specifically what you told him about it, and why you told him at that time? Rebozo: No, other than, he had been involved in fundraising and it wasn't going to be any secret. I guess I just told the key people that should know about it. Lenzner: Did you ask whether you should send the money back? Did that question arise? Rebozo: Well, that was April 30th, 1973, and I think the decision was already made then. If I did ask, it was just for his opinion. Lenzner: Since you had already decided, did you communicate, tell him that you had already decided to send the money back? Rebozo: I don't know. No. Because, as I recall the part about the Hughes money, it was just an irrelevant part of the conversation. Lenzner: The purpose of the meeting was not to discuss that. Rebozo: No. Lenzner: Did he ask you specifically about the Hughes money, Kalmbach? Rebozo: He didn't ask me. I told him, and I think that's the first time that I told him. I'm not sure, it may have been earlier. I don't know. just like there may have been some others I told at that time. It's a bit of a dilemma. I hated to see it go back if it could be used, but I had clung to vain hope longer than perhaps I should have. Lenzner. Did you have other discussions with Kalmbach? Rebozo. I don't think so. Lenzner. Do you remember any reaction that Kalmbach had at that time when you told him about the funds? Rebozo. No, I can't say that I do. Lenzner. Was he concerned that there may have been a problem your having received these funds? Any concern about that? Rebozo. I don't know. I think he had enough. I think he had enough concern of his own to be concerned about the fact that I don't recall. Lenzner. Did he discuss any of his problems he was facing? Rebozo. No, I was reading about his. Lenzner. Did he seem surprised to learn of these funds, or did he appear to know about them? Rebozo. If he was, I don't recall his showing it. I think in the campaign, as I told you last time, that I was asked if Hughes had made a contribution in 1968. I said he had, but nobody questioned that a check turned in. In 1972, I handled this as best I could. Lenzner. Who asked you about the Hughes thing? Rebozo. I think that Herb did. I can't be sure, but I think he had. Richard Danner testified on Tuesday, December 18, 1973, that the first occasion on which he was informed that the money had not been used and that Rebozo wanted to return the money was on May 18, 1973, at the Madison Hotel in Washington, D.C., in a discussion that Danner had with Rebozo. Mr. Danner also responded to further questioning about the return of the money as follows. Lenzner. Did Mr. Rebozo indicate whether he had discussed the return of the money with anybody else? Danner. No, he didn't mention that. And I asked him if he had consulted with an attorney or taxman or anyone of that sort, and he said no, he hadn't, and I suggested that he had better do that. On March 28, 1974, William Griffin testified under oath before the Senate Select Committee that he met with B.B. Rebozo in either late April or May 3, 1973, and that Mr. Rebozo explained to him that he had $100,000 in a safe deposit box at the Key Biscayne Bank, and that the money was the same money he had been given in 1969 and 1970. Griffin could not recall whether Mr. Rebozo said that he was going to meet with the Internal Revenue agents or he had just met with them. Griffin placed the date of his first meeting with Rebozo in late April 1973, but his first airplane ticket showing a trip down to Key Biscayne from New York was dated May 3, 1973. However, both of those dates are prior to May 10, 1973, when Rebozo first met Internal Revenue agents and told them that they were the only ones that knew that the money was still in the safe deposit box in the Key Biscayne Bank. On March 21, 1974, Herbert Kalmbach testified that on the evening of April 29, 1973, he received a call from B.B. Rebozo, who requested a meeting with him the following morning. Kalmbach said that he met with Rebozo on the following morning, April 30, 1973, at about 8 in the morning, and after they discussed such matters as refinancing of San Clemente and the president's taxes, Rebozo asked Kalmbach if he could go on attorney-client basis in discussing a personal problem. Kalmbach testified that Rebozo said, "The president had asked him to speak to me about this problem and not Maurice Stans." Kalmbach stated that Mr. Rebozo said the IRS had scheduled a meeting with him on the subject of a $100,000 contribution from Howard Hughes, which Mr. Rebozo received in 1969 and 1970. Kalmbach then testified that Rebozo said that he had dispersed part of the funds to Rose Woods, to Don Nixon, to Ed Nixon, and to unnamed others during the intervening years. Kalmbach further testified, "In response to my questions, he reiterated that the money had been given to him as a contribution by Hughes, and that the expenditures he had made to several individuals, including Rose and the president's two brothers, had come from the Hughes cash." Kalmbach then testified that he advised Rebozo to get the best tax lawyer he could and to lay out the facts exactly to the Internal Revenue Service. Kalmbach said that Rebozo replied to his advice, expressing grave reservations about following it for the stated reason that This touches the president and the president's family, and I can't do anything to add to his problems at this time, Herb." Kalmbach testified that he checked with another attorney, Stanley Ebner, in the White House, who agreed completely with his advice when presented in a hypothetical context. Kalmbach stated that he met Mr. Rebozo again the following morning, May 1, 1973, at around 8:30 a.m. Kalmbach testified that he began to recount his visit with Stan Ebner, but before he had finished, Rebozo cut short further discussion with a somewhat baffling comment that he saw no problem, but he thanked me for my thoughts. Kalmbach also testified that he had a third meeting with Bibi Rebozo on Tuesday, January 8, 1974, at about 8:30 in the morning at the San Clemente Western White House. Kalmbach recalled that at one point toward the end of his meeting on January 8th, Rebozo told him words to the effect that, "Undoubtedly, Herb, I have not told you that after you and I talked last spring regarding the Hughes money, I found that I had not in fact disbursed any of the Hughes cash to the several people I named. When I went to the safe deposit box, I found that the wrappers around that cash had not been disturbed, so it was clear that no part of this money had been used during the several years it was in my box." In an affidavit sworn on May 14, 1974, Mr. Jim O'Connor, Kalmbach's attorney, stated that following Kalmbach's meeting with Rebozo on or about April 30th, Mr. Kalmbach discussed with the affiant, Jim O'Connor, the fact that after discussing the San Clemente matter and the handling of the tax affairs of the President, and after stating that the attorney-client relationship did indeed exist, Mr. Rebozo advised Mr. Kalmbach that he had given some of the $100,000 in question, which had been given to him by Danner, to Rosemary Woods and to the Nixon brothers, and Mr. Rebozo asked Mr. Kalmbach what he should do. In addition, Margaret C. Blakely, Jim O'Connor's secretary, filed an affidavit on May 15, 1974, which stated that on or about the middle of October 1973, she was asked by Mr. O'Connor to call Mr. Rebozo to inform him that Mr. Kalmbach had been questioned by the Special Prosecutor's Office and by Terry Lenzer on October 11th and 12th concerning a meeting on April 30th, 1973, with Mr. Rebozo. And Mr. Kalmbach acknowledged the meeting took place at or about that time. Mr. Kalmbach further advised both investigating parties that the prime purpose of the meeting was to review certain matters involving the President's personal affairs, including the sale of the Whittier property and the refinancing of the San Clemente property, among other things, that Mr. Kalmbach was disturbed about reports that campaign funds were used in the acquisition of the San Clemente property, etc. Blakely also swore that on or about January 25, 1974, she was again asked to contact Rebozo, and when Mr. Rebozo returned her call, she read to him a memorandum as follows. If Mr. Kalmbach is pressed as to any details of a conversation between himself and Mr. Rebozo on April 30th and or May 1st, he, of course, would have to tell the truth. That in the unlikely event he is pressed on this matter, he will of course state that these discussions were pursuant to the attorney-client relationship and therefore subject to the attorney-client privilege. On May 20, 1974, the following exchange occurred during Mr. Rebozo's testimony. Mr. Lenzner: Did you ever make the statement to anybody that you had used the money or had somebody else use it on behalf of other individuals? Mr. Rebozo: No, sir, I don't think anybody else did either. Rebozo also testified on March 21, 1974, that he ran into Herb Kalmbach at the White House on April 30, 1973, and asked for his judgment on whether or not Rebozo should return the money. Then the following exchange occurred on March 21, 1974. Mr. Lenzner: Did you explain to him again that you had received the funds and that you had kept them, and why you kept them? Mr. Rebozo: I think I passed over that. Mr. Lenzner: And I take it you did tell him you kept it because you were asking for his judgment on whether you should return them or not? Mr. Rebozo: That's right. Mr. Lenzner: Did you ask him to do anything other than giving you his judgment at that time? Mr. Rebozo: No. Mr. Lenzner: Did you ever discuss with him again the $100,000 contribution from Hughes? Mr. Rebozo: I don't think so. I've seen very little of him. That may be the last I saw him. There was further discussion on March 21st about Rebozo's meeting with Kalmbach. The exchange follows. Mr. Lenzner: We talked, I think, to Mr. Kalmbach sometime in October or November of 1973. Did he ever advise you of those discussions? Mr. Rebozo: No, I don't think so. I don't know. I don't think I've seen Kalmbach. Yes, I did see him once in California since that meeting we just referred to, April 30th, 1973. That simply had to do with the grounds, the presidential grounds out there, the certain repairs that need to be made, and so on. Mr. Lenzner: There was no discussion on that occasion about the Hughes contribution of $100,000? Mr. Rebozo: No. Mr. Lenzner: I'm sorry, sir? Mr. Rebozo: No. Mr. Lenzner: You told him then on April 30th that basically that you had retained the same funds that had been given to you previously. Did you tell him when you received these funds, Mr. Kalmbach, on April 30th, Mr. Rebozo? Mr. Rebozo: No, actually at that time I wasn't even sure when I'd received it. That was established later. Mr. Lenzner: And you did tell him that they were the same funds and you wanted to know what to do about it? Mr. Rebozo: Yes. Later, on March 21st, Rebozo was asked if he ever discussed with Haig, Garment, Ehrlichman, Griffin, and Kalmbach the issue of whether the funds had been used or not. Mr. Rebozo replied, That was not an issue. They had not been used. I still have the funds. Lenzner added, So the answer is no, you had never discussed with any of these individuals. Mr. Rebozo replied, No. Rebozo also testified on March 21, 1974, that he had no financial or business transactions with Edward Nixon, the president's brother. Rebozo denied that he had given Edward Nixon any gifts in excess of $1,000. Rebozo also denied that he had ever had any financial or business transactions with Rosemary Woods, except for the Fisher's Island transaction. Rebozo also denied that he had ever given money in excess of $1,000 to Rosemary Woods. Rebozo denied ever furnishing any money to F. Donald Nixon. Rebozo also testified that he had not given any gifts of cash or stock or any other negotiable commodity of value in excess of $1,000 to President Nixon. I. Camp David Meeting. On March 21, 1973, Rebozo testified that he recalled meeting Richard Danner in Washington in May 1973, but he did not recall asking Danner to come to Washington for the meeting. Rebozo also testified that, after talking to Danner on May 18th or 19th, Rebozo decided to have President Nixon talk personally to Danner about the mood of the people he was seeing in Las Vegas, and so he called an aide to have him bring Danner up to Camp David in a courier car. Rebozo also testified that he asked the president to come over to Rebozo's cottage to have Danner relate to the president the mood of the people of the West. Rebozo testified that he did not recall the president was present at the meeting for more than 10 minutes. Rebozo could also not recall the kind of day it was on Danner's visit, nor did he recall taking a walk with Danner and President Nixon on the Camp David grounds. Richard Danner testified on December 18, 1973, that Rebozo had been wanting to see me prior to Danner's coming into Washington on May 18, 1973. Danner also testified that Rebozo told him that President Nixon wanted to talk to Danner and that he was picked up by a car and driven to Camp David on May 20, 1973. Danner testified that he met with Rebozo and the president beginning around 12 noon and that, "We talked in the room for perhaps an hour, and then we took a walk. I remember it because it was misting rain and I didn't have a raincoat, but we took quite a walk around the compound, and he was showing me various places and what was being done, and this probably lasted until 2 o'clock, something like that." Danner reconfirmed his testimony of December 18, 1973, in another executive session on June 11, 1974, in which he detailed the walk that he and President Nixon and Rebozo took around the compound. Danner also testified that his meeting with President Nixon was certainly more than a 5-minute meeting. Finally, weather reports indicate that on May 20, 1973, a light rain fell on Camp David, Maryland. J. IRS investigation. Mr. Rebozo testified in the morning of March 21st that he first learned about the IRS investigation into the Hughes matter when the agent called from Las Vegas and wanted to come and see me, and we set up an appointment. Rebozo denied that he ever talked with Ehrlichman about the $100,000 contribution, or that Ehrlichman ever called to alert him that the IRS would soon call and request an interview about the Hughes matter. However, in the afternoon session on March 21st, Rebozo testified, "I think that perhaps I ought to correct a misunderstanding I may have made to Senator Weicker earlier, because I was asked about Ehrlichman, and I do recall that Ehrlichman did mention the IRS to me. I didn't recall any specific conversation, but now I do remember that he, Ehrlichman, said something about the IRS was going to check this out." Mr. Ehrlichman testified on February 8, 1974, that he called Mr. Rebozo at the request of Roger Barth of the IRS to notify Rebozo that the IRS wanted to interview him about whether or not Rebozo had received funds from the Hughes organization. Finally, Roger Barth testified that he called Rebozo to notify him of the IRS request for an interview. Barth testified that he acted at Ehrlichman's request. End of section 24. Section 25 of the Watergate Report, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 3. Chapter 8. The Hughes-Rebozo Investigation and Related Matters, Part 18. 12. Summary. The transmittal of $100,000 in $100 bills from Howard Hughes to President Nixon's close friend, Charles G. Rebozo, several years prior to the 1972 election, reflects a number of classic issues inherent in the furnishing of large cash contributions to political campaigns. 1. Why were cash funds furnished to a close friend of the president rather than to any campaign official or organization? 2. Why were the funds contributed several years prior to the 1972 campaign for which they were allegedly intended, especially since Howard Hughes ultimately contributed another $150,000 in 1972 to the Finance Committee to re-elect the president? 3. Did Howard Hughes profit in any way by his contribution to Rebozo on behalf of the president? Mr. Rebozo's testimony about the matter steadfastly rejects any notion of impropriety in his receipt and handling of the two $50,000 cash contributions. He has testified that he finally agreed to accept the Hughes contribution in 1970 after rejecting it many times in 1968 and 1969 because of the possible embarrassment it might cause President Nixon. That the contribution was intended solely for the president's 1972 re-election campaign. That he placed the two $50,000 cash contributions in his safe deposit box without counting them and with instructions to his attorney to turn the money over to the president's campaign in case anything happened to Rebozo. That he subsequently destroyed these instructions sometime after the December 1970 split between Hughes and Mayhew, thereby leaving $100,000 in $100 bills in his safe deposit box with no evidence of the money's origin or purpose. That he subsequently removed the wrappers with the words Las Vegas from the money and wrapped the money in rubber bands while again not counting the money. That he did not use any of this money for any purpose and that he returned the same identical $100 bills to Mr. Hughes in the spring of 1973. That he told only Rosemary Woods of the receipt of the funds until after the 1972 election, when he informed President Nixon, and that he informed others of the contribution after he decided to return the money, and that he had no discussions about the money with President Nixon and Mr. Danner on May 20, 1973, at Camp David, despite the fact that the meeting occurred after Rebozo had decided to return the money and before Danner agreed to accept it. Indeed, Rebozo has maintained in all his testimony that his initial apprehension over accepting the cash contribution from Howard Hughes was exacerbated by the very public conflict that had erupted in late November 1970 between Robert Maheu and Howard Hughes. Had Rebozo understood the funds to be intended for the congressional races, he could easily have turned them over to the appropriate congressional campaigns prior to the conflict that later caused him such apprehension. And while the publicized confrontation between the Hughes factions may have deterred Rebozo from applying funds to any campaign for 3 to 4 years, Rebozo testified that he never once attempted to contact any representative of Hughes, any representative of the Republican National Committee, or any representative of the president's reelection campaign to seek advice with regard to the funds until well after the 1972 presidential election. In fact, in early 1972, Rebozo began receiving and accepting a variety of contributions, properly established a bank account for such funds, and acknowledged the receipt of such funds to both the donors and the Finance Committee to re-elect the president. At no time, however, did he acknowledge in writing to Hughes or his representatives the receipt of the $100,000, nor did he ever notify, as he did with other contributions in 1972, any campaign officials the receipt of $100,000 until after the election. While Mr. Rebozo has always maintained that the funds were intended for the president's campaign, he has also testified that he maintained the $100,000 well after the 1972 election because he believed it could be used for the 1974 congressional campaign or 1976 presidential election. Mr. Rebozo also insists that he never discussed the contribution with the president until well after the 1972 election, and that Danner is mistaken in stating that he, Rebozo, and the president met in 1968 and discussed the possibility of obtaining a contribution from Howard Hughes. Rebozo has testified that while he met with Mr. Danner on May 18 and May 20, 1973, in Washington to discuss the return of the contribution, at no time was the contribution discussed in the presence of President Nixon on May 20 at Camp David. Rebozo concedes that one of the issues discussed with Danner, both at a hotel in Washington and at Camp David before the president arrived, was his desire to return the funds to Danner. But Rebozo insists that the only topic discussed after the president arrived was Danner's perception of the mood on the West Coast with regard to Watergate. The president, of course, knew by the time he met with Danner at Camp David that Rebozo had in fact been the recipient of a substantial contribution from the Hughes organization. The president, therefore, would have been fully aware that he was in the presence of the principals who had been involved in a contribution in which the IRS had suddenly expressed an interest. In any event, President Nixon, through his press spokesman, has denied any conversation ensued during that meeting with regard to the Hughes $100,000. In addition, of course, the committee received evidence indicating that the president, prior to his meeting on May 20, 1973, with Danner and Rebozo, requested Rebozo to discuss with Herbert Kalmbach the issue of the receipt, use, and possible return of the Hughes $100,000 on or about April 30, 1973. The committee also received testimony from Larry Higbee that on or about April 30, 1973, H.R. Haldeman told Higbee that the president informed Haldeman that Rebozo had available approximately $400,000 to defray legal fees for both Haldeman and John Ehrlichman. Much of the above information was contained in a letter Chairman Ervin and Vice Chairman Baker sent to the president's counsel, Mr. St. Clair, on June 6, 1974. This letter contained additional specific information, including evidence that the president requested that Mr. Rebozo contact J. Paul Getty regarding major contributions, evidence that Rebozo maintained a fund in Key Biscayne to take care of administration-connected costs, and a list of specific expenditures on behalf of the president exceeding $50,000 that were ordered and paid for by Rebozo. These listed expenses on President's Key Biscayne properties included substantial alterations of the president's home and construction and equipping of a pool for the president. In his letter on behalf of President Nixon, dated June 20, 1974, St. Clair conveyed the President's assurance that he never instructed C.G. Rebozo to raise and maintain funds to be expended on the President's personal behalf, nor, so far as he knows, was this ever done. In addition, the President, through St. Clair, declined to comment with regard to any of the expenditures amounting to over $45,000 that Rebozo furnished on behalf of the President. On the basis of the evidence reflected in the letter to Mr. St. Clair, Chairman Ervin sought to provide Rebozo with an opportunity to furnish information and documents to assist the committee in reviewing the evidence obtained by the staff. On one occasion, in fact, Rebozo and his counsel agreed to provide the committee with certain documents the committee had sought through subpoena and to provide additional information through testimony. Instead of complying with the subpoena and furnishing the documents pursuant to the agreement entered into, however, Rebozo and counsel moved to quash the subpoena, both in court and before the committee. The committee, by unanimous vote, rejected Rebozo's application, and the Federal District Court for the District of Columbia recently denied an effort to enjoin the committee's subpoena and investigation of Rebozo. Indeed, when an additional subpoena and letter was issued by Chairman Ervin in an effort to obtain Rebozo's responses to questions based on the above-described information, Rebozo was in Europe and therefore unavailable for the process of the subpoena. As a result, certain crucial testimony and documentation which was deemed necessary by the committee to clarify the factual matters related in this report have been denied the committee, and the discrepancies and conflicts in testimony have not been finally resolved. As a result, the committee has before it evidence which suggests a number of possible alternative resolutions of the factual material presented herein. 1. That Rebozo paid for the President's expenses out of his own funds. Since Rebozo declined to furnish the committee with all personal documents and with the pertinent documents from his bank, the committee has been unable to make a judgment with regard to this matter, except to the extent of determining, based on the records that were provided by Rebozo, that the great portion of expenditures made for the President were not made out of Rebozo's bank account, and those made in currency were not made from Rebozo's personal funds derived from known sources. 2. That the President, in effect, paid for these expenses himself, by later reimbursing Rebozo. While Rebozo's refusal to produce records and the President's failure to respond to specific issues in the letter of June 6 has hampered the committee's ability to make a judgment on this issue, the committee finds only one reimbursement, the $13,642 check discussed in the body of the report. Moreover, the committee notes that the Coopers and Lybrand report to the President made no mention of any outstanding liabilities due Rebozo. 3. That Rebozo paid for the expenditures on behalf of the President from another source of funds. The testimony and evidence before the committee indicates that the only other sources of funds available to Rebozo were campaign contributions. Again, the failure of key witnesses to comply with subpoenas frustrated the committee's efforts in conclusively resolving this issue. The Select Committee diligently attempted to determine which one of these three alternative conclusions is accurate. It could have undoubtedly made such a determination if Rebozo had made all of the records controlled by him or his bank relating to these matters available to the committee, or if the President had availed himself of the opportunity to clarify or explain these matters which was extended to him in the June 6, 1974, letter from Senator Ervin, the committee chairman, and Senator Baker, vice chairman, to his lawyer, Mr. St. Clair. Mr. Rebozo persisted in his refusal to make records controlled by him or his bank relating to these matters available to the committee, and placed himself beyond the reach of the committee by traveling to Europe, when he had reason to know that the remaining life of the committee precluded it from enforcing further subpoenas on him or others. And, unfortunately, the President did not avail himself of the opportunity to clarify or explain the matters arising out of his dealings and relationship with Rebozo. In view of the above, the committee finds it appropriate that the matters set forth herein be pursued further by relevant investigative bodies. 13. Legislative recommendations. 1. Communications between the White House and the Internal Revenue Service should be more strictly regulated. Specifically, A. Any requests, direct or indirect, for information or action made to the IRS by anyone in the Executive Office of the President, up to and including the President, should be recorded by the person making the request and by the IRS. Requests and responses by the IRS, i.e., whether information was provided, should be disclosed at least once a year to appropriate congressional oversight committees. B. On sensitive case reports, which cover special cases, the IRS should be permitted to disclose to persons in the Executive Office of the President, up to and including the President, only the name of the person or group in the report and the general nature of the investigation. C. All persons in the Executive Office of the President, up to and including the President, should be prohibited from receiving, indirectly or directly, any income tax return. D. All requests for information or action and all IRS responses should be disclosed periodically to the appropriate congressional oversight committees. There were numerous efforts by the White House to use the IRS for political purposes between 1969 and 1972. Particularly striking examples, such as attempts to use the IRS to harass persons perceived as enemies, have already been exposed and discussed at great length by the Select Committee and other groups. In addition, there was misuse of the IRS by the White House regarding the IRS investigations of Rebozo, the President's brothers, and people connected with the Hughes operation. Because of the close relationship of several of the parties to the President, questions of improper White House influence in this case are particularly acute. Recommendation A was prompted by examples of White House requests made regarding, among others, Larry O'Brien. In the spring of 1972, the IRS Commissioner, Johnny Walters, decided to postpone until after the November election any further investigation of several people who had close relations to prospective presidential nominees. These people included Larry O'Brien, the President's brothers, and Charles G. Rebozo. The decision was made as an effort to avoid any charges that the investigations were politically motivated. Roger Barth, then Assistant Commissioner of the IRS and a source of information for the White House, had told John Ehrlichman that O'Brien, the Nixon brothers, and Rebozo were or would be under investigation. At some point in the spring of 1972, Barth gave Ehrlichman a copy of a sensitive case report listing these names as subjects of interest to the IRS. Although it is not clear whether Ehrlichman was told about Walters' decision to postpone the investigations, it is clear that Ehrlichman pressured Barth, Walters, and George Shultz, Secretary of the Treasury, into pursuing intensely the O'Brien investigation in the hope that information damaging to O'Brien might be uncovered before the election. Understandably, Ehrlichman did not push the IRS on the investigations of Rebozo or the Nixon brothers. O'Brien was pursued and interviewed, but Rebozo and the Nixon brothers were not. Rather than trying to ban such requests from the White House, or delineate those requests that are proper, the most straightforward approach is to require disclosure of all requests. Those that are clearly improper, such as the Ehrlichman request on O'Brien, are less likely to be made if the requesting party knows that they will be disclosed to Congress. There have been, of course, proper White House requests to the IRS in this and preceding administrations. There is no reason to think that the effective functioning of the White House or the IRS will be impaired by the disclosure of such requests. Recommendation B was prompted by the Select Committee's discovery that sensitive case reports on people involved in some way with Hughes were given regularly to John Ehrlichman by Roger Barth, apparently without the knowledge of Barth's superiors, including Commissioner Walters. Because some of those reports touched upon Rebozo and possibly on the President himself, the potential value of those reports to the White House is obvious. There is no sound policy reason for providing the White House with the details of ongoing investigations, and such disclosure could seriously mar the IRS's reputation for impartiality. There are, however, legitimate reasons for providing the White House with enough information on sensitive cases to identify the person or group involved and the general nature of the IRS inquiry. For example, if the president were considering someone for appointment to a high federal position, he should be able to know whether that person's tax status is under any particular scrutiny. Similarly, the president should be able to learn whether any of his aides or intimates are under investigation. Limiting disclosure by the IRS to identification of the party under investigation and a general statement about the investigation should provide enough information for the White House to decide what to do about the situation, i.e., continue to support or perhaps withdraw a nomination. Requests for this basic information on sensitive case reports and the IRS's responses to the requests would, of course, be disclosed to the appropriate congressional committees under Recommendation A. Recommendation C was prompted by those instances where individuals in the executive office of the president would seek and receive copies of income tax returns. Generally, these were the returns of individuals perceived as enemies of the White House. That the returns were oftentimes sought and used for improper political purposes is clear. A statute prohibiting the receipt of income tax returns by those in the executive office of the president would do much to curb these improper practices. In addition, by making receipt, rather than distribution, criminal, the statute would eliminate those instances where returns could be obtained indirectly from a governmental agency, e.g. a U.S. Attorney General's office, which has full disclosure with the IRS. 2. Congress should enact legislation requiring full financial disclosure by the President and Vice President of the United States to the General Accounting Office each year of all income, gifts, and things of value that they or their spouses have received during the year, or expenditures made for their personal benefit or the benefit of their spouses by other individuals. Senators Ervin and Talmadge voted against the recommendation because they believe that public officials should be judged on the basis of the wisdom or unwisdom of their official actions, and not upon the basis of what they do or do not possess in this world's goods. Presently, legislation requires that congressmen and senators file statements of financial disclosure each year. Certainly, the head of the executive branch of the government should be held to no less a standard than the members of the legislature, and perhaps even held to a higher standard of disclosure because of the significance of his position. Full financial disclosure by the president and vice president to the public each year would also help protect the office of the president, ensuring that no individual occupying the office would be the object of any speculation, innuendo, or suggestion of impropriety regarding income, gifts, and expenditures. In addition, such a standard of full public disclosure would help to raise the ethical standards by which the public views its elected officials, and would restore a measure of confidence in the workings of government. Examples of items which should be disclosed include the following: copies of tax returns, declarations, statements, or other documents which were made individually or jointly for the preceding year in compliance with the provisions of the Internal Revenue Code. The identity of each interest in real or personal property having a value of $10,000 or more, which the president or vice president or spouses owned at any time during the preceding year. The identity of each trust or other fiduciary relation in which the president or vice president or spouses held a beneficial interest having a value of $10,000 or more, and the identity, if known, of each interest of the trust or other fiduciary relation in real or personal property in which he or she held a beneficial interest having a value of $10,000 or more at any time during the preceding year. The identity of each liability of $5,000 or more owned by the president or vice president, or by them jointly with their spouses, at any time during the preceding year, and the source and value of all gifts received by the president, vice president, or spouses in the aggregate amount or value of $50 or more from any single source received during the preceding year. The information required to be filed with the GAO would be made public automatically unless there were some overriding reason to protect the confidentiality of the information. In such a case, The information would still be available to any standing, select, or special committee of either House of Congress upon the receipt by GAO of a resolution requesting the transmission of such information. 3. State and local bar associations should conduct a study of the attorney-client privilege in light of the abuses of the privilege uncovered during the Select Committee's investigations. A strong attorney-client privilege is essential to the effective functioning of our legal system. It must be broad enough to encourage full disclosure by client, including disclosure of past criminal conduct. At the same time, the privilege should not be used to protect from disclosure communications involving violations of law and near violations that have nothing to do with the offering of legal advice by a lawyer. Providing information to a person who happens to be a lawyer, or involving him or her in one's affairs, should not automatically cloak the transaction with the protections of the privilege. In at least 4 instances during the Select Committee's investigations, the lawyer-client privilege has been pleaded as part of an attempt to cover up illegal or questionable activities that had nothing to do with the rendering of legal advice. 1. Martian and Liddy in the Watergate cover-up. 2. Dean and Segretti in the Watergate Dirty Tricks cover-up. 3. Kalmbach and Rebozo in the Hughes-Rebozo cover-up. 4. Wakefield and Rebozo, also in the Hughes-Rebozo area. A review of these cases by the various bar associations should help to clarify the proper limits of the privilege and provide more detailed guidance for lawyer, clients, and legislative and investigative bodies. End of section 25.
Section 26 of the Watergate Report, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Mary Ann Spiegel. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 3, Chapter 9, The Select Committee in Court. Roman 1. Overview of litigation. More than most congressional committees in recent memory, the Select Committee, during its short lifespan, has been involved in various types of court proceedings. In total, the committee participated in over 60 different matters before the federal courts. These ranged from the routine, for example, obtaining writs of habeas corpus ad testificandum to secure the testimony of incarcerated witnesses, to the complex, for example, the committee's suit to obtain certain presidential tapes and materials, Senate Select Committee versus Nixon. The suit against the president was the only proceeding in which the committee and its members appeared as plaintiffs in the traditional sense. However, the committee was a successful applicant for orders allowing it to confer limited or use immunity on 29 potential witnesses, thereby permitting it to obtain their testimony notwithstanding their assertion of the privilege against self-incrimination. A table providing the names of individuals for whom court orders allowing the conference of immunity were obtained and other information relating to those orders is found in the appendix to the hearings of legal documents, hereinafter L.A. for legal appendix. The committee also successfully sought writs of habeas corpus ad testificandum on 22 occasions that allowed it to obtain the testimony of several federal prisoners. Because other congressional committees may want to apply for immunity orders and habeas writs in the future, the legal appendix contains representative pleadings and other papers filed to achieve these results. The committee also appeared as amicus curiae in 4 lawsuits, including the litigation brought by the first special prosecutor to obtain presidential tapes and documents, Nixon versus Sirica, 487 Fed 2nd, 700, U.S. Court of Appeals, D.C. Circuit, 1973. And the committee was a defendant in 8 suits brought to prohibit or alter its proceedings. All these actions against the committee failed. 4 of the committee's litigative efforts are of particular importance. The tapes case, Senate Select Committee versus Nixon, has already been mentioned and receives further discussion below. Also important are application of the United States Senate Select Committee on Presidential Campaign Activities. This matter involved an unsuccessful attempt by the first special prosecutor to have the court impose conditions, most importantly, a requirement that testimony be taken without television and radio coverage, on the grant of authority to the committee to confer limited immunity on John Dean and Jeb Magruder, who otherwise would have been excused from testifying upon the assertion of their privilege against self-incrimination. The district court's opinion in this matter, which totally rejected the notion that a court could condition the issuance of an immunity order on the acceptance of restrictions by a congressional body, is reprinted in the appendix. See also at 361 Fed Sup. 1270, 1973. National Citizens for Fairness to the Presidency, Inc., et al., v. Senate Select Committee, et al. In this case, the plaintiffs, who contended that the committee's public hearings had disrupted domestic tranquility to the public detriment, unsuccessfully attempted to block those public hearings. Richard Danner, et al., v. Senate Select Committee, et al. The Summa Corp., formerly Hughes Tool Corp., and certain of its employees failed in this lawsuit to prevent the taking of their testimony in executive or private session. These cases raised numerous fundamental questions concerning the role of Congress in our system of government and, particularly, its relationship with the two other coordinate branches. For example, the right of Congress to investigate criminal conduct, the duty of Congress to inform the public by publicizing its findings of executive misdeeds, the power of Congress to obtain information for its investigations from the executive branch, by subpoena if necessary, where a claim of executive privilege is raised, the authority of the federal courts to entertain suits between Congress and the executive, the authority of Congress to conduct its investigations in secret until it decides publicly to disclose its findings, the right of Congress to investigate criminal conduct against the claim that fair trials might be impaired, the requirements of due process in regard to congressional hearings, the scope of congressional immunity under the Speech and Debate Clause of the Constitution. Because these issues are explored in detail in the pleadings in these lawsuits, they are not analyzed here. Rather, we have included the major papers submitted in these litigations in the appendix to the hearings of legal documents. While the committee's papers were often filed under considerable time pressures dictated by the exigencies of the moment, they do present basic statements of congressional rights, duties, and prerogatives respecting the issues outlined above. Other legal documents of relevance besides those mentioned are also included in the appendix, as its table of contents indicates. Some additional comments respecting Senate Select Committee v. Nixon and Danner v. Senate Select Committee are necessary because the committee's experiences in these cases give rise to several recommended reforms in the law that are outlined below. 1. Senate Select Committee v. Nixon. To date, the only recorded civil suit in history by the Congress against the President for production of material relating to presidential communications was filed on August 9, 1973, shortly after the President dishonored two subpoenas issued to him on July 23, 1973, which sought 5 specified tape recordings of presidential conversations and other White House documents and materials. The existence of these tapes had been revealed to the public on July 16, 1973, through the testimony to the committee of Alexander P. Butterfield, a former deputy assistant to the President. The committee issued its subpoenas and filed its suit against the President only after informal attempts to obtain tapes and other relevant material from the President had failed. The committee chose this route to enforce its subpoenas because it appeared unseemly to attempt enforcement by initiating statutory contempt proceedings against the President. See 2 U.S.C. 192, or by employing the self-help measures at the Senate's command. See, for example, Journey v. McCracken, 294 U.S. 125, 1935. On August 29, 1973, the first day possible after the complaint was filed, the committee submitted a motion for summary judgment requesting a declaratory judgment that its subpoenas were valid and should be honored. As the record shows, the committee sought expedition of this litigation at every stage. However, on October 17, 1973, the District Court, Sirica, Chief Justice, dismissed this action for lack of jurisdiction. Meanwhile, the special prosecutor's case for certain presidential tapes and documents was making its way through the courts. Special Prosecutor Cox was eventually successful in obtaining most of the material sought. See Nixon v. Sirica Supra. Because his litigation was ancillary to a grand jury proceeding, the special prosecutor was not troubled with questions of jurisdiction and other problems that attend civil litigation, as was the Select Committee. The committee appealed Judge Sirica's ruling on October 19, 1973. 2 days after appeal was noted, Senators Ervin and Baker, at the President's behest, met with the President and 2 of his counsel at the White House. After that meeting, it was suggested in the press that these senators had agreed to a compromise of the committee's lawsuit, whereby the committee would forego its litigation in exchange for summaries of certain tapes that would be verified by Senator John Stennis. The next day, October 20th, the first special prosecutor was dismissed for not agreeing to the so-called Stennis Compromise, and the Attorney General, Elliot Richardson, and the Deputy Attorney General, William Ruckelshaus, resigned. The fact of the matter as reported to the Court of Appeals on October 23, 1973, is that Senators Ervin and Baker agreed to no such compromise. While the President unilaterally offered certain materials to the committee, there was not even a tentative commitment by its chairman and vice chairman that, as a quid pro quo, the suit would be withdrawn. To the contrary, it was clearly understood by Senators Ervin and Baker that the committee, in all events, could pursue its lawsuit. Moreover, these two senators understood that the President was offering the committee verbatim transcripts of the conversations at issue, not mere summaries. As it happened, the Stennis Compromise never materialized, and the suit continued. The committee was and is of the view that Judge Sirica's jurisdictional ruling, particularly in regard to the requirements of 28 U.S.C. 1331, the basic federal question jurisdiction provision, constitutes both a misstatement and a misapplication of existing law. Nevertheless, while the case was on appeal, Senator Ervin introduced, and the Congress soon passed, a bill giving the district court jurisdiction over this and other cases brought by the Select Committee to enforce subpoenas issued by it to the executive branch. The bill, which was not vetoed by the President, became Public Law 93-190 on December 19, 1973, after the President failed to sign it within 10 days of transmittal to him. Public Law 93-190 does not cover suits brought by other congressional bodies against the executive branch for production of information. Senator Ervin initially, on November 2, 1973, had introduced a more inclusive bill that would have provided jurisdiction for all suits to enforce congressional subpoenas issued to the President or other officers and employees of the executive branch by either House of Congress, any committee or subcommittee of either House, or any joint committee of Congress. The bill that eventually became Public Law 93-190 was substituted for this proposal. The Senate also, on November 7, 1973, promulgated Senate Resolution 194, 93rd Congress, First Session, which affirmed that the Select Committee was authorized by the Senate to subpoena and sue the President. Senate Resolution 194 also declared it was the sense of the Senate that the committee, in subpoenaing and suing the President to obtain the information in question, was acting with valid legislative purpose and seeking information vital to its legislative missions. On January 25, 1974, Judge Gazelle, to whom the case had been reassigned upon remand, declined to enforce the committee's subpoena that called for a number of unspecified documents and other materials, on the grounds that it was too vague, particularly in view of the stringent requirements established by Nixon v. Sirica, applicable where a claim of executive privilege is raised. The same judge, on February 8, 1974, while ruling for the committee on basic issues such as invalidity of the President's claims regarding executive privilege, justiciability, and relevance of the material sought under Senate Resolution 60, declined to enforce the committee's other subpoena for 5 specified tape recordings and dismissed the litigation without prejudice. The court's ruling was grounded on its view that enforcing the subpoena and releasing the tapes to the committee might give potential defendants in the Watergate trials the opportunity to contend with greater force that their trials had been irrevocably prejudiced by pretrial publicity. Between the date of the lower court's ruling and the issuance of the Court of Appeals opinion on May 23, 1974, 2 highly significant events occurred. First, the House Judiciary Committee, which was considering the President's impeachment, received copies of the 5 tape recordings at issue in the Select Committee's suit. Second, the President released to the public partial, unauthenticated transcripts of these 5 conversations, among others. The Court of Appeals subsequently affirmed the lower court's ruling, but not for the reasons posited by the district court. The appellate court began by holding that presidential conversations are presumptively privileged, and that this presumption can be defeated only by a strong showing of public need by the institution of government seeking access to the conversations, a showing that the responsibilities of that institution cannot be reasonably fulfilled without access to records of the President's deliberations. The court then stated, particularly in light of events that have occurred since this litigation was begun, and, indeed, since the district court issued its decision, we find that the Select Committee has failed to make the requisite showing. Because the House Judiciary Committee possessed copies of the 5 recordings in issue, the court held that the Select Committee's subpoena could not be sustained on the basis of a need to fulfill Congress's informing and oversight functions. And because partial transcripts of the 5 conversations involved had been partially released, and it appeared that the impeachment findings of the House would, in the near future, be made public, the Court held that the committee had not shown that the matter sought was critical to its lawmaking functions. It is clear, therefore, that the Court's decision rested, as the Court observed, on the peculiar circumstances of this case, and should not necessarily prevent legislative committees in the future from obtaining materials relating to presidential communications. Moreover, because of the unique factual context, the Court's opinion should have little relevance in the future respecting congressional efforts to achieve executive branch materials that do not concern presidential conversations or deliberations. It is noteworthy, in terms of the recommendations we present below, that the Attorney General filed an amicus curiae brief in the Court of Appeals opposing the committee's contentions. A similar antagonism to the congressional position was in evidence in Application of United States Senate Select Committee, where the special prosecutor opposed the committee's stand that the district court had no power to condition the grant of an immunity order. 2. We conclude this brief review by noting that Danner v. Select Committee, the litigation brought by the Summa Corporation and others to prescribe the taking of testimony in executive session, raised an important question respecting the right of the Senate under existing law to conduct sensitive investigations in private session. Section 190A-1B of Title II provides, each hearing conducted by each standing, select, or special committee of the Senate, except the Committee on Appropriations, shall be open to the public except when the committee determines that the testimony to be taken at that hearing may relate to a matter of national security, may tend to reflect adversely on the character or reputation of the witness or any other individual, or may divulge matters deemed confidential under other provisions of law or government regulations. The committee, respecting the investigation involved in the Danner suit, had no difficulty making the determination specified in the statute because the possibility of defamation and the revelation of national security matters was established. But, as discussed in more detail below, there may come times when a senatorial committee would need to conduct its investigations in secret for other legitimate reasons. Roman II. Discussions and recommendations. 1. The committee recommends that Congress enact legislation giving the United States District Court for the District of Columbia jurisdiction over suits to enforce congressional subpoenas issued to members of the executive branch, including the President. This statute, which would apply to all subpoenas issued by congressional bodies, would replace the special statute passed for and limited to the Select Committee that is now codified as 28 U.S.C. 1364. The statute should provide that a congressional body has standing to sue in its own name and in the name of the United States and may employ counsel of its own choice in such a suit. The statute should provide that suits brought to enforce congressional subpoenas must be handled on an expedited basis by the courts. The Congress continually needs information from the executive branch to fulfill its critical oversight and informing functions. A major lesson of Watergate is the need for vigorous congressional oversight. Without the committee's hearings, many of the salient facts respecting the Watergate affair, including the existence of the presidential tapes, might never have surfaced. Moreover, the Supreme Court has long stressed the vital importance of Congress's role as the informer of the public of wrongdoing, inefficiency, and waste in the executive branch. Congress can often force production of information from the executive by use of political sanctions. For example, administration bills can be voted down, appropriations denied, nominations rejected. But frequently these political devices are not available. At times, a congressman can obtain information like any other citizen under the Freedom of Information Act, but there are many limitations to that statute's applicability. Congress also has available, to redress the refusal to comply with a subpoena, its self-help powers or the statutory contempt procedures contained in 2 U.S.C. 192. But these drastic remedies are often time-consuming and singularly inappropriate where high executive officials are involved. The impeachment process is likewise a manifestly awkward vehicle by which to force executive production of evidence. It thus seems appropriate to provide another remedy to Congress to allow it promptly to enforce its subpoenas against the executive, the ability to bring an expedited civil action to achieve a ruling on the validity and enforceability of congressional subpoenas. The Congress would not be forced to use this method of enforcing its subpoenas, but it would be available if other remedies were not suitable. Moreover, disputes between Congress and the executive often involve constitutional questions that the federal courts, as the ultimate interpreters of the Constitution, are well equipped to resolve. 2. The Select Committee recommends that Congress give careful consideration to the bill now before the Senate, Senate 2569, that would establish a congressional legal service and thus give Congress a litigation arm that would allow it to protect its interest in court by its own counsel. As the suit to obtain presidential materials and the litigation involving the Dean-Magruder immunity orders demonstrate, there are times when Congress's interests diverge from those of the executive. Indeed, in those two cases, the two branches were pitted against each other and their immediate interests were largely conflicting. In many instances where congressmen are parties to litigation, they are represented by the Department of Justice. But such an arrangement is obviously unacceptable where executive interests conflict with congressional interests. The Select Committee, which had a litigating staff, was able to conduct its own lawsuits, but many congressional committees, not similarly staffed, might find litigation activity difficult. The establishment of a congressional legal service would provide Congress a permanent litigation arm and thus meet this problem. 3. The Select Committee recommends that Congress amend 2 U.S.C. 190A-1B to allow a senatorial committee or its staff to take testimony and evidence in private session upon an express determination by the committee that the requirements of efficient production and investigation so require, and that the investigation would be materially harmed if a regimen of confidentiality were not imposed. The amended statute, however, should provide that testimony or evidence taken in confidence for these reasons should be released to the public as soon as the requirements of efficient investigation no longer demand confidentiality. Section 190A-1B, as it now stands, does not fully meet the needs of an investigative committee, especially one exploring sensitive or criminal matters. While the general proposition that senatorial hearings should be public is sound, it must be recognized that efficient investigatory techniques require that, at times, testimony and evidence be received in confidence. Such occasions may arise in circumstances not now covered by 2 U.S.C. 190A-1B, which only provides for private hearings where defamation or the release of national security information might result, or where confidentiality is required by federal law or regulation. For example, in many circumstances, testimony and evidence should be taken in private to prevent leads from drying up or witnesses from disappearing, or it might be necessary to withhold the testimony of one witness from a subsequent witness to avoid the tailoring of later testimony. Moreover, in circumstances such as those experienced by the Select Committee, where many hundreds of witnesses were interviewed in private throughout the nation, both in executive session before a senator and in private staff interviews, it is simply not efficient to require that all investigatory sessions be conducted in public. Section 190A-1B could justifiably be interpreted as not applying to informal staff interviews, but, in any event, amendment of this section is necessary to allow the full utilization of efficient investigatory procedures. Because the general policy of open government reflected in the current Section 190A-1B is salutary, the amendment we propose would provide that the evidence taken in private sessions would be made public as soon as proper investigatory techniques no longer require that it be kept private. End of Section 26. Section 27 of the Watergate Report, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Marianne. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 3. Chapter 10. The Select Committee's Use of Computer Technology. Roman 1. Introduction and Overview. To accomplish its investigative task, the staff of the Select Committee had to analyze a considerable amount of information available concerning the Watergate incident and related activities. Included among this data was the transcript of the Watergate trial held in January 1973 and the various newspaper articles published since the break-in on June 17, 1972. In addition, many interviews, investigative reports, and much documentary evidence had to be obtained for the committee to conduct a thorough investigation. In early March, the committee's information was processed by hand. An elaborate file card indexing technique was employed patterned after one used by military intelligence agencies. Trained researchers would read testimony and documentary evidence and abstract the facts contained therein. References to each person discussed, along with the date of the activities testified about and the location of the activities were included with the paragraph or abstract. This data, after being taped on cassette tape records, was transcribed onto 3x5 cards. One card was made for each person, date, and location discussed, and placed in 3 files. Thus, staff members could utilize any of the files. By the middle of March, over 10,000 file cards had been produced, yet the backlog of information available had scarcely been processed. Other problems developed. Since there was only one complete file card system, only one person could employ the system at a time. The size of the file made reproduction of the system for each individual's use impracticable. To prepare reports about individuals, dates, or general events, the card file had to be totally reviewed by hand, consuming valuable time, and given the time frame within which the committee had to operate, it was believed that this procedure would seriously affect the total investigation. Therefore, in late March, the Select Committee decided to explore the possibility of using automation to facilitate organization and analysis of the information to be collected. Samuel Dash and members of the Select Committee staff met with Paul Reimers, Coordinator of Information Systems, and other persons from the Library of Congress Information Systems Office. The requirements of the system were established. A generalized file system was needed with full text processing and all Boolean search capability. The Select Committee had to be able to formulate its search request with both positive and negative qualifiers. An updating capability had to be a major feature of the system since new information would be continually obtained by the Select Committee. Lastly, but probably most important, the Select Committee's security procedures precluded use of an online system. Therefore, the proposed system would have to allow for batch application processing. After a few meetings in early April, it became apparent that a computer system did exist that was well suited to fulfill the needs of the Select Committee. It was BIBSYS, BIBSYS. The Bibliographic System, or BIBSYS, is part of the Library of Congress Information Network designed to enable the user to establish and maintain a machine-readable information file. Using a modified machine-readable catalog, Mark II, internal processing format, it can produce a variety of reports from the database. For example, some of those envisioned during the meetings were cross-reference reports on individuals mentioned, special reports on specific individuals mentioned, chronological date of event reports, and KWIC, keyword in context, indexes, all of which are discussed below. Tags were used to identify fields of data at the time of data entry, but without compromising the use of the data in later processing. The technique required a minimum of machine identification data to be input in conjunction with the textual information. The subsystems of BIBSYS, developed for the Select Committee's use, were the file maintenance cycle, the retrieval system, the field inversion cycle, and the report cycle. The Library of Congress made available for the Select Committee's use the following hardware: one IBM 370 Mod 145, 512K, three 3330 disk packs, and one 2314 disk pack, two 2400 tape drivers using 9-track tapes, 1600 BPI, two 1403 line printers, one 2501 card reader, and a digidata converter for MTST input. The software consisted of OS VS1 operating system, sort and utilities, ANS COBOL compiler version 2, 12 application programs written in ANS COBOL, and 2 ALC application programs. With the approval of the Select Committee, the computer operation was inaugurated. Within 2 weeks, sample programs had been adapted for the committee's use and tested. Sample records were processed in early May, approximately 1 week before the public hearings began. The tests were successful. On May 15, 1973, using a borrowed staff of key-to-tape operators, the first actual records were input. Roman II. Processing the data. The input procedures were simple yet comprehensive. Each bit of testimony, either public or confidential, was read by a staff of trained researchers who abstracted out the essential facts. These researchers dictated the source of the information or the witness, the date the testimony was given, and the geographic location at which the testimony was taken. The title of the document and the page number from which the facts were abstracted was also included. Following this, a complete summary of the information was dictated onto the tape. To ensure a chronological sorting capability, researchers were instructed to produce one abstract for testimony concerning activities on a certain date. Through this method, as will be discussed later, the data could be sorted in a day-by-day chronological order. The remaining fields in the records contained references to persons quoted by the witness and the date of the quote, persons acting in the testimony along with the date and location of the activity. Lastly, each record was categorized into 44 general subject topics, delineating the general areas under investigation. Once this was dictated by the researchers, the cassette tapes were given to a secretarial staff which transcribed the information onto input sheets. These sheets were returned to the computer research staff for a series of editorial changes, both substantive and technical. Each sheet was reviewed for accuracy 3 times before it was ready for computer input. After the editorial process was complete, the records were given to 2 key-to-tape machine operators who transferred the information onto magnetic tape. Once on tape, the information was printed out from the computer tapes or dumped to ensure that no other errors existed. These preliminary printouts or dumps were then edited for substantive and technical errors. The tape, with corrections, was returned to the key-to-tape machine operators who corrected the errors on the tape. The tapes were then ready for the actual input into the machine. This initial process was later altered with the advent of magnetic tape selectric typewriters, MTSTs. The use of these machines enabled the computer staff to eliminate 2 steps in the input process. Since a skilled secretary could format the data by adding the appropriate computer codes directly from a cassette tape, there was no longer any need to type up input sheets. Secondly, the MTST machines simultaneously stored the data on magnetic tape cartridge and provided a readable copy of the data on tape. Therefore, the staff no longer needed to dump or print out the tapes created. The computer used by the Select Committee was an IBM 370-145, located at the Library of Congress Annex. Elaborate security measures were implemented designed to ensure that no unauthorized individual or organization could obtain information from the computer database. It was decided that no data would be stored at the library itself. Instead, the master tapes containing all the data collected were kept secure within the Select Committee's files. When the actual processing took place on Monday, Wednesday, and Friday from midnight to 6 a.m., the tapes were delivered to the computer room by a Select Committee staff courier along with a police escort. Once in the machine room, the courier was not permitted to leave the tapes alone, and only he, a systems analyst, and an operator were permitted in the room during the processing of the data. When Select Committee data was processed, no non-committee applications were run simultaneously. A completely dedicated machine was used to ensure no spillover of data from or to the Select Committee's computer file. Upon completion of the processing, the courier, under police guard, returned to the Select Committee's offices with the tapes and any readable data. Roman 3. Format of the data. Each bit of information or record consisted of 8 fields of data. The first field contained a number uniquely identifying the record. The second field contained 4 subfields: the name of the person or organization that was the source of the abstract, the date the testimony or data was given, a computerized transfiguration of that same date listing the year, month, and day in a 6-digit number, and the city, state, or location at which the information was taken. The next field contained the title of the document from which the abstract was taken. The microfilm number, indicating on which roll and frame the document abstracted from was filmed, was included in this field. After the third field, the abstract was included. These were summaries of the factual testimony given. During the public hearings, only facts relating to the events under investigation were abstracted. Discussions of legal principles, Select Committee procedure, and anecdotes were not abstracted. In most cases, the abstracts were based upon testimony given concerning a certain date or event. They were not verbatim accounts of the actual testimony. After the abstract, there existed in most every record a field which contained comments by the abstractor. These comments ranged from identifying the date of the transaction to pointing out that the abstract was inconsistent with previously given testimony, or identifying a person involved in the transaction who was not otherwise identified during the specific testimony abstracted. After the comment, the abstractor who inserted the comment included his or her name and the date the comment was inserted into the record. The sixth field, which followed, contained the names of any individuals quoted in the abstract, along with the date the quote was made. As mentioned before, each record contained a cross-reference list of all persons or organizations acting in the abstract. This was included in the seventh field. There were 4 subfields to this field. The first contained the name of the person or organization, the second contained the date that person acted, the third listed the 6-digit transfiguration of the computer date, and the fourth was the location that the person or organization acted. Each record contained a variable number of these fields based mainly on the nature of the abstract. After the cross-reference field, each record contained at least one subject topic field. These fields contained 3-digit number designations of specific subject topics and were designed to fit the various areas under investigation. This record format permitted the Select Committee to analyze the stored data in the following methods: name discussed, date of event, subject matter, persons quoted, witness, and source document. Part of the record input into the machine was a reference to each person or organization about which the abstract dealt. In addition, the date this person or organization acted was included. Therefore, requests could be and were structured to instruct the computer to retrieve all records with an individual's name in this reference field, and then to sort all those records in chronological order based upon the date associated with that name. The result, a chronological report of every fact about which testimony had been given concerning any individual or organization mentioned. Since reconstructing a sequence of events was vital to the Select Committee's investigation, this was also a major feature of the computer's capability. Through proper programming, a complete chronological listing of events could be reconstructed based upon all the records input into the database. This enabled the staff to retrieve testimony from a multitude of witnesses concerning a particular date or series of dates, and then analyze, given the nature or the source of the information, that is, whether it was from a newspaper article or given under oath, what actually happened. Each record, as mentioned before, was categorized into various subject areas. If the testimony dealt with the Watergate phase of the investigation or campaign financing phase, it was appropriately coded as such. These subject codes enabled the staff of the Select Committee to retrieve and analyze data concerning general events within the overall investigation. They could also be added as positive or negative qualifiers to other retrieval requests to limit the topical scope of a computer run. For example, a request could be made for all testimony about a certain individual, but only if that information dealt with the general Watergate phase of the investigation or selected areas within the other phases of the investigation. Additionally, the format of the records permitted the staff to obtain information from any document where a particular person was the source or where a specific individual was quoted. This request could be limited so that information was retrieved from certain documents, either as a group, to wit, only executive sessions or interviews or public statements under oath or individually, such as a particular person's interview, an executive session or public testimony before the Select Committee. Thus, once testimony was placed on computer tapes, the problems previously experienced with the card file system were alleviated. The references could be rearranged on the machine's disk packs and then printed out in a desired format. Since it was done through automation rather than manual review of a card file, the time necessary to complete the request was minimal. Roman IV. Investigative use of the computer. Since time constraints precluded training each staff member computer request methodology, the Select Committee created a specially trained staff to act as a liaison between the investigative staff and the computer systems analyst. Requests from the investigative staff were thus translated into the necessary computer terminology by the computer staff. When a particular witness or series of witnesses was to be interrogated, a request was made to retrieve from the computer all the information the Select Committee had collected. For security reasons, no staff member could obtain a computer printout without first receiving written authorization from either the Chief Counsel or Chief Minority Counsel. This ensured that the heads of the staff knew who was getting what information. During the public hearings, printouts on the upcoming witnesses were run regularly. Given the inputting system employed, it was possible to have 1 week's testimony in the computer ready for retrieval and analysis before the beginning of hearings the following week. Thus, to maintain a complete file, new testimony was continually being integrated with data obtained from prior witnesses. Printouts of information on each new witness were distributed to the Chief Counsel and the Chief Minority Counsel. The printouts listed all information in the computer file about the witness that had been stored in the machine up to that date. Once provided, the printouts served as an additional source upon which interrogation were based. The same procedure was followed for confidential interviews and testimony taken in executive session. Printouts were produced, integrated into the staff member's personal notes, and the interrogation undertaken. With the computer's facility to not forget and a properly entered name, date, or subject matter, the interrogator had at his fingertips all information about the person to be interrogated. Since data was input into the machine at least 3 times per week, the printouts produced were very much up to date. A source document title along with the pages from which the facts were abstracted was included with each abstract. This enabled the user, if necessary, to go to the original document to obtain the verbatim account. In addition, the computer was employed to sort and analyze other data. The Select Committee subpoenaed telephone records from a number of individuals. These records were presented to the staff of the committee in the form of the monthly bill statements received by the person under subpoena from the telephone company. A separate computer file was established listing the telephone number from which the call was made, the number to which the call was placed, the date of the phone call, the locations, city, state, of both phone numbers, the time of day of the call, designated in terms of a 2400-hour clock, 1630, 0843, etc., as well as the duration of the call. Collect calls and those made from phones other than the business or home phone of the caller, yet nonetheless billed to either the home or business phone of the caller, were also included in the file. Approximately 12,000 telephone calls were input into this file. Printouts were prepared upon request that retrieved and sorted phone calls from one number to another, all calls to one specific number or series of numbers owned by an individual, phone calls made during a specific time period, etc. Thus, the staff was able to review thousands of telephone calls quickly and efficiently. Through the use of a master list of telephone numbers and corresponding owners, the staff could isolate contacts between particular persons either generally or on specific dates from data that was accurately collected by an independent entity, the telephone company. Roman 5. Cooperation with other investigative bodies. Special Prosecutor Archibald Cox, shortly after his appointment on May 18, 1973, held a series of meetings with the Select Committee's chief counsel. Mr. Cox realized that his office, too, could alleviate many of the information retrieval problems facing it through the use of a computer. After a few meetings between the members of his staff and the Select Committee computer staff, Special Prosecutor Cox requested the Select Committee provide his office with all public information from its computer tapes. In addition, since the system was a totally new one, it was agreed that the Select Committee would train personnel from his staff to abstract testimony and input it into the computer. For 3 weeks, personnel from the Special Prosecutor's Office were trained by the computer staff of the Select Committee. From September 14, 1973, to the end of January 1974, the Select Committee made available to the Special Prosecutor over 10,000 records containing public information. By doing so, it saved the Special Prosecutor's Office the almost 20,000 man-hours it had taken the Select Committee to computerize the information. On March 5, 1974, Senator Ervin, responding for the entire committee to a request by then Special Prosecutor Jaworski, agreed to turn over all materials in the Select Committee's files that would aid him in his investigation. This agreement included all information on computer tapes, over 25,000 records. In January 1974, the House Judiciary Committee, investigating the possible impeachment of the President, was, just as the Special Prosecutor, faced with the problem of devising an information retrieval system. Mr. John Doerr, Special Counsel to the Judiciary Committee, requested information from the Select Committee's computerized files. On February 7, 1974, the Select Committee met and agreed to furnish the House Judiciary Committee with all information on its computer tapes. 1 week later, duplicates of all the Select Committee's computer tapes were turned over to the House Judiciary Committee, a transfer of information saving them thousands of man-hours. After receiving many requests from various state and local bar associations for information concerning possible unethical conduct on the part of attorneys in the Watergate incident, the committee decided that it would be compatible with its investigation to supply public information in printout form. Using as a conduit for requests the American Bar Association's Center for Professional Discipline, the committee made available to those bar associations public information in printout form on individuals identified by the associations as being under investigation. Requests for public information printouts were also made to the committee by attorneys representing individuals indicted for their participation in the Watergate incident. Knowing the tremendous value of computerized printouts and that these trials were to determine ultimate individual criminal liability, the committee felt, out of fairness, that these printouts should be made available to the defendants. On May 9, 1974, the committee in executive session unanimously voted to make available to these individuals, at their expense, printouts of public information and any confidential information that the person making the request had given to the Select Committee. Roman 6. Microfilm procedure. All documentary evidence obtained by the committee and maintained in the security area was microfilmed to allow for greater accessibility of this material to the staff. Because of security procedures, all filming and processing of the film was done on the premises of the committee. 2 microfilm viewers were installed to allow for immediate viewing and analysis by any staff member. The computer record format had been adopted to provide for the microfilm number, indicating the roll and frame number where the document could be found. It was included in all printouts. Roman 7. Disposition. Pursuant to Senate Resolution 369, the Select Committee, at the termination of its activities, transferred its records, including computer tapes, to the Library of Congress. The Senate Committee on Rules and Administration was empowered to exercise exclusive control of and access to the use of such records. In so doing, the Senate Rules Committee was directed to make parts of such records or certified copies of the same available to courts, the special prosecutor, congressional committees and subcommittees, federal departments or agencies, or individuals satisfying the Senate Committee on Rules and Administration of their legitimate need for parts of such records. Thus, the information retrieval system that was responsible for the efficient and effective way in which the Select Committee conducted its investigative and reporting functions was made available to the above mentioned for future application. Moreover, the Senate Committee on Foreign Relations became the first standing committee of Congress to utilize the system in almost the same form used by the Select Committee. It is a fitting commendation for the system that was conceived so rapidly, yet worked so well, that its use be perpetuated by the Congress of the United States. End of section 27. Section 28 of the Watergate Report, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Marianne. A final report of the Senate Select Committee on Presidential Campaign Activities, Volume 3. Chapter 11. Individual Views of Senators of the Select Committee, Part 1. Mr. Sam J. Ervin, Jr., U.S. Senator from the state of North Carolina. Since the Senate Select Committee on Presidential Campaign Activities is filing with the Senate its final report concerning the investigation that body authorized and directed it to make, I deem it appropriate to state as succinctly as possible some of my personal observations respecting the tragic events known collectively as the Watergate, which disgraced the presidential election of 1972. In doing this, I ask and endeavor to answer these questions. What was Watergate? Why was Watergate? Is there an antidote which will prevent future Watergates? If so, what is that antidote? Before attempting to answer these questions, I wish to make these things plain. 1. I am not undertaking to usurp and exercise the power of impeachment which the Constitution confers upon the House of Representatives alone. As a consequence, nothing I say should be construed as an expression of an opinion in respect to the question of whether or not President Nixon is impeachable in connection with the Watergate or any other matter. 2. Inasmuch as its Committee on the Judiciary is now studying whether or not it ought to recommend to the House the impeachment of the President, I shall also refrain from making any comment on the question of whether or not the President has performed in an acceptable manner his paramount constitutional obligation to take care that the laws be faithfully executed. 3. Watergate was not invented by enemies of the Nixon administration, or even by the news media. On the contrary, Watergate was perpetrated upon America by White House and political aides, whom President Nixon himself had entrusted with the management of his campaign for re-election to the presidency, a campaign which was divorced to a marked degree from the campaigns of other Republicans who sought election to public office in 1972. I note at this point without elaboration that these White House and political aides were virtually without experience in either government or politics apart from their association with President Nixon. 4. Life had not subjected these White House and political aides to the disadvantaged conditions which are glibly cited as the causes of wrongdoing. On the contrary, fortune had smiled upon them. They came from substantial homes, possessed extraordinary talents, had had unusual educational opportunities, and occupied high social positions. 5. Watergate was unprecedented in the political annals of America in respect to the scope and intensity of its unethical and illegal actions. To be sure, there had been previous milder political scandals in American history. That fact does not excuse Watergate. Murder and stealing have occurred in every generation since Earth began, but that fact has not made murder meritorious or larceny legal. What was Watergate? President Nixon entrusted the management of his campaign for re-election and his campaign finances to the Committee for the Re-election of the President, which was headed by former Attorney General John N. Mitchell, and the Finance Committee to re-elect the President, which was headed by former Secretary of Commerce Morris Stans. Since the two committees occupied offices in the same office building in Washington and worked in close conjunction, it seems proper to call them for ease of expression the Nixon re-election committees. Watergate was a conglomerate of various illegal and unethical activities in which various officers and employees of the Nixon re-election committees and various White House aides of President Nixon participated in varying ways and degrees to accomplish these successive objectives. 1. To destroy, insofar as the presidential election of 1972 was concerned, the integrity of the process by which the President of the United States is nominated and elected. 2. To hide from law enforcement officers, prosecutors, grand jurors, courts, the news media, and the American people the identities and wrongdoing of those officers and employees of the Nixon re-election committees, and those White House aides who had undertaken to destroy the integrity of the process by which the President of the United States is nominated and elected. To accomplish the first of these objectives, the participating officers and employees of the re-election committees and the participating White House aides of President Nixon engaged in one or more of these things. 1. They extracted enormous contributions, usually in cash, from corporate executives by impliedly implanting in their minds the impressions that the making of the contributions was necessary to ensure that the corporations would receive governmental favors or avoid governmental disfavors while President Nixon remained in the White House. A substantial portion of the contributions were made out of corporate funds in violation of a law enacted by Congress a generation ago. 2. They hid substantial parts of these contributions in cash in safes and secret deposits to conceal their sources and the identities of those who made them. 3. They dispersed substantial portions of these hidden contributions in a surreptitious manner to finance the bugging and the burglary of the offices of the Democratic National Committee in the Watergate complex in Washington for the purpose of obtaining political intelligence, and to sabotage by dirty tricks, espionage, and scurrilous and false libels and slanders the campaigns and the reputations of honorable men whose only offenses were that they sought the nomination of the Democratic Party for president and the opportunity to run against President Nixon for that office in the presidential election of 1972. 4. They deemed the departments and agencies of the federal government to be the political playthings of the Nixon administration rather than impartial instruments for serving the people, and undertook to induce them to channel federal contracts, grants, and loans to areas, groups, or individuals so as to promote the re-election of the president rather than to further the welfare of the people. 5. They branded as enemies of the president individuals and members of the news media who dissented from the president's policies and opposed his re-election, and conspired to urge the Department of Justice, the Federal Bureau of Investigation, the Internal Revenue Service, and the Federal Communications Commission to pervert the use of their legal powers to harass them for so doing. 6. They borrowed from the Central Intelligence Agency disguises which E. Howard Hunt used in political espionage operations, and photographic equipment which White House employees known as the plumbers and their hired confederates used in connection with burglarizing the office of a psychiatrist which they believed contained information concerning Daniel Ellsberg, which the White House was anxious to secure. 7. They assigned to E. Howard Hunt, who was at the time a White House consultant occupying an office in the Executive Office Building, the gruesome task of falsifying State Department documents, which they contemplated using in their altered state to discredit the Democratic Party by defaming the memory of former President John Fitzgerald Kennedy, who as the hapless victim of an assassin's bullet had been sleeping in the tongueless silence of the dreamless dust for 9 years. 8. They used campaign funds to hire saboteurs to forge and disseminate false and scurrilous libels of honorable men running for the Democratic presidential nomination in Democratic Party primaries. During the darkness of the early morning of June 17, 1972, James W. McCord, the security chief of the John Mitchell Committee, and 4 residents of Miami, Florida, were arrested by Washington police while they were burglarizing the offices of the Democratic National Committee in the Watergate complex to obtain political intelligence. At the same time, the 4 residents of Miami had in their possession more than 50 $100 bills, which were subsequently shown to be a part of campaign contributions made to the Nixon re-election committees. On September 15, 1972, these 5 burglars, E. Howard Hunt and Gordon Liddy, general counsel of the Stans Committee, were indicted by the grand jury on charges arising out of the bugging and burglary of the Watergate. They were placed on trial upon these charges before Judge John Sirica and a petit jury in the U.S. District Court for the District of Columbia in January 1973. At that time, Hunt and the 4 residents of Miami pleaded guilty, and McCord and Liddy were found guilty by the petit jury. None of them took the witness stand during the trial. The arrest of McCord and the 4 residents of Miami created consternation in the Nixon re-election committees and the White House. Thereupon, various officers and employees of the Nixon re-election committees and various White House aides undertook to conceal from law enforcement officers, prosecutors, grand jurors, courts, and the news media, and the American people, the identities and activities of those officers and employees of the Nixon re-election committees and those White House aides who had participated in any way in the Watergate affair. Various officers and employees of the Nixon re-election committees and various White House aides engaged in one or more of these acts to make the concealment effective and thus obstruct the due administration of justice. 1. They destroyed the records of the Nixon re-election committees antedating the bugging and the burglary. 2. They induced the acting director of the FBI, who was a Nixon appointee, to destroy the State Department documents which E. Howard Hunt had been falsifying. 3. They obtained from the acting director of the FBI copies of scores of interviews conducted by FBI agents in connection with their investigation of the bugging and the burglary, and were enabled thereby to coach their Confederates to give false and misleading statements to the FBI. 4. They sought to persuade the FBI to refrain from investigating the sources of the campaign funds which were used to finance the bugging and the burglary. 5. They intimidated employees of the Nixon re-election committees and employees of the White House by having their lawyers present when these employees were being questioned by agents of the FBI, and thus deterred these employees from making full disclosures to the FBI. 6. They lied to agents of the FBI, prosecutors, and grand jurors who undertook to investigate the bugging and the burglary, and to Judge Sirica and the petit jurors who tried the 7 original Watergate defendants in January 1973. 7. They persuaded the Department of Justice and the prosecutors to take out-of-court statements from Morris Stans, President Nixon's chief campaign fundraiser, and Charles Colson, Eagle Krogh, and David Young, White House aides, and Charles Colson's secretary, instead of requiring them to testify before the grand jury investigating the bugging and the burglary in conformity with the established procedures governing such matters, and thus denied the grand jurors the opportunity to question them. 8. They persuaded the Department of Justice and the prosecutors to refrain from asking Donald Segretti, their chief hired saboteur, any questions involving Herbert W. Kalmbach, the president's personal attorney, who was known by them to have paid Segretti for dirty tricks he perpetrated upon honorable men seeking the Democratic presidential nomination, and who was subsequently identified before the Senate Select Committee as one who played a major role in the secret delivery of hush money to the 7 original Watergate defendants. 9. They made out cash payments totaling hundreds of thousands of dollars out of campaign funds in surreptitious ways to the 7 original Watergate defendants as hush money to buy their silence and keep them from revealing their knowledge of the identities of the officers and employees of the Nixon re-election committees and the White House aides who had participated in the Watergate. 10. They gave assurances to some of the original 7 defendants that they would receive presidential clemency after serving short portions of their sentences if they refrained from divulging the identities and activities of the officers and employees of the Nixon re-election committees and the White House aides who had participated in the Watergate affair. 11. They made arrangements by which the attorneys who represented the 7 original Watergate defendants received their fees in cash from monies which had been collected to finance President Nixon's re-election campaign. 12. They induced the Department of Justice and the prosecutors of the 7 original Watergate defendants to assure the news media and the general public that there was no evidence that any persons other than the 7 original Watergate defendants were implicated in any way by any Watergate-related crimes. 13. They inspired massive efforts on the part of segments of the news media friendly to the administration to persuade the American people that most of the members of the Select Committee named by the Senate to investigate the Watergate were biased and irresponsible men motivated solely by desires to exploit the matters they investigated for personal or partisan advantage, and that the allegations in the press that presidential aides had been involved in the Watergate were venomous machinations of a hostile and unreliable press bent on destroying the country's confidence in a great and good president. One shudders to think that the Watergate conspiracies might have been effectively concealed, and their most dramatic episode might have been dismissed as a third-rate burglary conceived and committed solely by the 7 original Watergate defendants, had it not been for the courage and penetrating understanding of Judge Sirica, The thoroughness of the investigative reporting of Carl Bernstein, Bob Woodward, and other representatives of a free press, the labors of the Senate Select Committee and its excellent staff, and the dedication and diligence of Special Prosecutors Archibald Cox and Leon Jaworski and their associates. Why was Watergate? Unlike the men who were responsible for Teapot Dome, the presidential aides who perpetrated Watergate were not seduced by the love of money, which is sometimes thought to be the root of all evil. On the contrary, they were instigated by a lust for political power, which is at least as corrupting as political power itself. They gave their allegiance to the president and his policies. They had stood for a time near him and had been entrusted by him with great governmental and political power. They enjoyed exercising such power and longed for its continuance. They knew that the power they enjoyed would be lost, and the policies to which they adhered would be frustrated if the president should be defeated. As a consequence of these things, they believed the president's re-election to be a most worthy objective, and succumbed to an age-old temptation. They resorted to evil means to promote what they conceived to be a good end. Their lust for political power blinded them to ethical considerations and legal requirements, to Aristotle's aphorism that the good of man must be the end of politics, and to Grover Cleveland's conviction that public office is a public trust. They had forgotten, if they ever knew, that the Constitution is designed to be a law for rulers and people alike at all times and under all circumstances, and that no doctrine involving more pernicious consequences to the common weal has ever been invented by the wit of man than the notion that any of its provisions can be suspended by the President for any reason whatsoever. On the contrary, they apparently believed that the President is above the Constitution and has the autocratic power to suspend its provisions if he decides in his own unreviewable judgment that his action in so doing promotes his own political interests or the welfare of the nation. As one of them testified before the Senate Select Committee, they believed that the President has the autocratic power to suspend the Fourth Amendment whenever he imagines that some indefinable aspect of national security is involved. I digress to reject this doctrine of the constitutional omnipotence of the President. As long as I have a mind to think, a tongue to speak, and a heart to love my country, I shall deny that the Constitution confers any autocratic power on the President or authorizes him to convert George Washington's America into Gaius Caesar's Rome. The lust for political power of the presidential aides who perpetrated Watergate on America blinded them to the laws of God as well as to the laws and ethics of man. As a consequence, they violated the spiritual law which forbids men to do evil even when they think good will result from it, and ignored these warnings of the King James Version of the Bible. There is nothing covered that shall not be revealed, neither hid that shall not be known. Be not deceived, God is not mocked. For whatsoever a man soweth, that shall he also reap. I find corroboration for my conclusion that lust for political power produced Watergate in words uttered by the most eloquent and learned of all Romans, Marcus Tullius Cicero, about 2100 years ago. He said, "Most men, however, are inclined to forget justice altogether when once the craving for military power or political honors and glory has taken possession of them. Remember the saying of Aeneas, 'When crowns are at stake, no friendship is sacred, no faith shall be kept.'" As one after another of the individuals who participated in Watergate goes to prison, we see in action an inexorable spiritual law which Rudyard Kipling phrased in this fashion in his poem about Tomlinson's ghost. "For the sin ye do by two and two, you must pay for one by one." As we contemplate the motives that inspired their misdeeds, we acquire a new awareness of the significance of Cardinal Wolsey's poignant lament. "Had I but served my God with half the zeal I served my King, he would not in mine age have left me naked to mine enemies." The antidote for future Watergates. Is there an antidote which will prevent future Watergates? If so, what is it? The Senate Select Committee is recommending the enactment of new laws which it believes will minimize the danger of future Watergates and make more adequate and certain the punishment of those who attempt to perpetrate them upon our country. Candor compels the confession, however, that law alone will not suffice to prevent future Watergates. In saying this, I do not disparage the essential role which law plays in the life of our nation. As one who has labored as a practicing lawyer, a judge, and a legislator all my adult years, I venerate the law as an instrument of service to society. At the same time, however, I know the weakness of the law as well as its strength. Law is not self-executing. Unfortunately, at times its execution rests in the hands of those who are faithless to it. And even when its enforcement is committed to those who revere it, law merely deters some human beings from offending, and punishes other human beings for offending. It does not make men good. This task can be performed only by ethics or religion or morality. Since politics is the art or science of government, no man is fit to participate in politics or to seek or hold public office unless he has two characteristics. The first of these characteristics is that he must understand and be dedicated to the true purpose of government, which is to promote the good of the people and entertain the abiding conviction that a public office is a public trust, which must never be abused to secure private advantage. The second characteristic is that he must possess that intellectual and moral integrity which is the priceless ingredient of good character. When all is said, the only sure antidote for future Watergates is understanding of fundamental principles and intellectual and moral integrity in the men and women who achieve or are entrusted with governmental or political power. Josiah Gilbert Holland, a poet of a bygone generation, recognized this truth in a poem which he called The Day's Demand, and which I like to call America's Prayer. I quote his words. God, give us men. A time like this demands strong minds, great hearts, true faith, and ready hands. Men whom the lust of office does not kill. Men whom the spoils of office cannot buy. Men who possess opinions and a will. Men who have honor. Men who will not lie. Men who can stand before a demagogue and damn his treacherous flatteries without winking. Tall men, sun-crowned, who live above the fog, in public duty and in private thinking. End of section 28.